Hello and welcome to Automotive Training Solutions ATS webinar session on Auto Dealership Quarterly Regulatory Update, Avoiding Deceptive Advertising webinar. My name is Hanan Bidri, ATS Managing Director, and I'll be moderating today's webinar. Today's presenter is Terry Franzine from Franzine and Salzona in Georgia. Terry Franzine co-founded Franzine and Salzona in 1997 and manages the firm's consumer financial services litigation and regulatory enforcement practice. In response to client requests, Terry co-founded Comply Share, a quality control and compliance company in 2008. She serves as counsel to the Georgia Independent Auto Dealers Association and many of its members. Terry serves on the council of the American Bar Association's Business Law section, on the editorial board of Business Law Today, and is immediate chair, past chair of the American Bar Association's Consumer Financial Services Committee. She is a fellow of the American College of Consumer Financial Services Attorneys, serves on the governing committee of the Conference on Consumer Financial Law, and is the counsel to and past president of the Georgia Real Estate Fraud Prevention and Awareness Coalition. Terry graduated from Summa Cum Laude with honors from the University of Georgia with an undergrad degree in history and from the University of Georgia School of Law. Prior to founding Franzine and Salzona, Terry served as general counsel of Fleet Finance. Previously, she managed the commercial litigation department at an Atlanta firm and spent 2 years as an assistant solicitor prosecuting primarily domestic violence cases in Cobb County, Georgia. Terry is admitted to practice in Georgia in the state, federal, and appellate courts. Terry has extensive experience helping clients comply with various state and federal laws which impact auto industry. She advises financial institutions and dealers nationwide on state and federal lending and loan servicing laws and regulations for loan and sales finance products on such matters as licensing, fees, loan documentation and disclosures, loan origination and servicing documents, state licensing applications and reports. She assists clients responding to and defending against state and federal examinations and investigations. She audits loan files, advertisements, and other marketing materials, policies, and procedures for compliance and applicable laws and regulations, and she counsels clients with regard to employment issues. Before we begin, I would like to go over a few housekeeping details. If you're faced with any technical problems, please contact GoToWebinar's tech support at 1-800-263-6317. For those of you who may not be familiar with GoToWebinars, please note that there's a control panel on the right side of your screen. The Control tab, please click on the plus symbol to expand the section and submit questions to the moderator. I will monitor incoming questions and will notify the speaker after the conclusion of her presentation. At this point, I would like to turn things over to Terry.
Wonderful. Thank you very much. It's wonderful to be with you all this afternoon. Weather is as lovely as ours is in Atlanta today. We finally have a beautiful sunny day as opposed to the rain that we've been having, although we hate to complain about rain, of course. So what I'm going to talk with you some this afternoon is how to avoid deceptive advertising. In our own practice here, our Governor's Office of Consumer Protection has been extremely busy, and they have been monitoring and various advertisements out there that both franchise and independent dealers place either on the web or in print or on the radio for that matter. And they have been quite active in sending enforcement actions if they find a problem with the advertisement. So we thought this would be a very timely topic for you guys this afternoon, and I hope that you learned something from the presentation. So throughout the presentation, you'll see references to either Georgia law, or sometimes to Washington law, which I know seems kind of weird, but it is on the other coast, so we thought we would include some of that. But I think one of the things to keep in mind, because I know that all of you are from different states, is that I think pretty much every state has a law which in many ways mirrors the FTC Act, which I hope you realize is an act which deals with deceptive disclosure, among other things. So as I say in the presentation, you'll see some specific references to Georgia, and I'll try to point those out to you as we go along. So my very first slide talks about disclosures in general, and I think it's something that probably everybody knows, that disclosures should be clear, conspicuous, they need to be accurate, and they need to be in immediate proximity to a term which they modify. We'll talk about what that means in a little more detail. The next point on this slide, that 10-point font must be used, and that your font should be the same throughout the ad. This is a state law requirement in Georgia, and as I say, I think it's a requirement in other states as well. I mean, sort of the bottom line is you can't have mice type, which provides important disclaimers to the borrowers or to the actually means. First of all, it's a term which is false. It's a notion which is false, or it might not be false, but it could be misleading, or it could be susceptible to both a misleading and a truthful interpretation. And in order for a regulator or a smart plaintiff's lawyer to find that an advertisement is deceptive, they need not find any consumer harm, and in fact, a consumer doesn't even need to complain to a regulator. As I say, the regulators are very diligent in looking at the advertisement and making sure that it's not deceptive to consumers. I think one thing that's important for us all to remember is that we are all consumers. But the thing that makes us different from the consumers that might walk into your is the special knowledge which you all have as being part of the auto industry. And so I think when you're looking at your own advertisements for your business, you need to keep that in mind and try to look at the advertisement with the eye of someone who is not knowledgeable in the industry, because that's the way that the regulators look at the advertisements. They try to look at the advertisements in the way, the term is the least sophisticated consumer, but basically they look at it the way that someone, like most consumers, walks into a car store, they want to buy a car. They're not knowledgeable about the car business other than they just know they need to buy a car. And so that's the way you need to view your advertisement. And one thing you might think about is to show advertisements to a member of your family even, and have them take a look at it and see if they understand what the advertisement is supposed to mean, and does it seem clear and does it seem truthful. So that's, I guess, one of my little practice pointers to you this afternoon. As I said at the beginning, in addition to state law, you also need to be concerned about the FTC Act. And the section of the Act that we need to be concerned about is Section 5A. And sometimes you'll hear people just in shorthand talk about Section 5 or Section 5A, what's an act. And it's that act that declares that unfair or deceptive acts or practices which affect commerce are unlawful. So, of course, car dealers affect commerce, so you guys come under the purview of this act. The act itself has a definition for the term unfair, and that definition is that the activity or the advertisement will cause or is likely to cause substantial injury to consumers, which is not reasonably avoidable by consumers themselves and which is not outweighed by the countervailing benefits to consumers or the competition. So that is the definition that's in the Act. And if you break that down, I mean, the part about whether it's cause or likely to cause substantial injury to the consumers, I guess I have a cynical view about that, but I think sometimes there's not a real concern about injury. As I told you previously, there doesn't have to be actual injury, and there doesn't even have to be an actual complaint. And then it needs to be something which is not reasonably avoidable by consumers themselves. Of course, a consumer cannot avoid an advertisement, so that's a big gotcha right there. And then what happens is they look at the overall advertisement themselves. So there might be other benefits within the advertisement, and it's whether that outweighs the portion of the advertisement which the regulator or a plaintiff's lawyer might think is unfair to a consumer. All right, so let's talk about some specific examples of items that regulators have found to be deceptive or unfair to consumers. So, for example, for used vehicles, sometimes you'll see an advertisement where the dealer has used what are stock photos. And here in Georgia and at the FTC, they say, no, you cannot do that. You have to use photographs of the exact vehicle. It cannot be a vehicle that looks like it. It cannot be a blue Camry if you happen to have a red Camry for sale on your lot. It needs to be a photo of the exact vehicle that's for sale. Now, for new vehicles, you can have a representative vehicle for the class or the type of particular vehicle that it is. Let me give you some examples that we've had problems. Some of our clients have had problems here in Georgia. One of them is that Georgia requires that you disclose the number of vehicles that are available at a particular advertised price. So if your advertisement says that you have 8 vehicles at, $20,000, you better have 8 vehicles at $20,000. And I can tell you that our Governor's Office of Consumer Affairs is pretty strict with regard to updates on a website, for example. And as you guys probably know, there's not an instantaneous update the very minute that you sell a vehicle from your lot. And sometimes that can be a problem. So I think you need to just be cognizant that you need to have the ability to update your website or other web advertising really pretty much on a daily basis to make sure that you're disclosing the exact number of vehicles that are available at a particular advertised price at a particular time. Now, you'll see in a lot of advertisement the term limited availability. And here in Georgia, that's fine, but it cannot be in mice type. You can't have a little asterisk and then in the lower right-hand corner in print that is so tiny that no one can read it, you have the term limited availability. That does not work. That term would need to be beside the vehicle that's being advertised in the same style and typeface as the rest of the advertisement. And that's true on your website as well. And I know I've talked with the web developers for some of our clients when they've had this issue. And, sometimes it's kind of hard to get those web developers to understand how important it is that every single item that our governor's office wants is, in fact, adequately complied with. If you are selling a specific vehicle, then you have to include the VIN in the advertisement itself. Again, they don't want you to advertise some vehicle that maybe you actually don't have on your lot. So this is an example of an advertisement. So you see at the top right-hand corner, it says there are 28 in stock. That's in really, I don't know what the font is, but fairly large font in a bright blue, pretty bright blue. Then in a smaller print in black in the lower left-hand corner, it says to at this price. So there's contradictory information in the advertisement itself. And I can tell you that our regulator here in Georgia would not be very happy about this. The next bullet on this particular slide talks about terms which, again, we see an awful lot, and that is the use of the terms liquidation, public sale, or auction. And it's pretty clear that those terms are deceptive unless these claims can be substantiated in fact. So obviously, you are having a public sale because you're open to the public. So, I think that's a term you should probably avoid. You shouldn't use the term auction unless, in fact, you're actually having an auction. And you should not use the term liquidation unless you're closing your business. So, as I say, every day I can go right up and down the road and see somebody who's having a liquidation sale, and then a month later they're still having the same liquidation sale. And I think that both the FTC and the state authorities would find that practice to be deceptive to consumers. So in the next slide, it gives just another example of some things that our local Georgia office has found to be deceptive. So if the car lot continues to sell the same year, make, and model of the vehicle after the liquidation sale is over, that's a problem. And in fact, our Georgia office requires you to disclose the expiration of the sale or of a particular advertised price, just to avoid this particular problem. Now let's talk about leases for a minute, because I don't know if it's because of the economy or exactly what's going on, but I know just in the last couple weeks I've heard many advertisements for leases. So if you're going to advertise a lease, then you have to include the payment which is due at the start of the lease, the number of payment periods, the cost of the lease, and the total of all the payments necessary in order to acquire full ownership of the vehicle. Let's talk about rebates. Again, this is a problem, I would say, quite often. So, and again, these are examples that we've had here in Georgia. So if the rebate is limited to a category within the model only, then any limitations have to be disclosed in the advertisement itself. If the rebate is incorporated in the advertised price, then you have to state that to the public. And if it's not incorporated in the advertised price, then you have to state that as well. So the example that I gave there, $18,000 after the rebate, is acceptable. All right, so let's talk about big sales events, which I know many dealers like to have. So these sales events are considered to be misleading if they are made to represent to the consumers that the sales are taking place outside of the dealership and therefore are not associated with a dealership. So for example, sometimes, well, we have a lot of vacant property here in Georgia, and I know some of our larger dealers will have a special sales event at some of that vacant property. And if that's the case, that's perfectly fine, except that you have to advertise the dealership, which is actually having the sale. So it can't be, I don't know, some unknown, and I don't really know why you would do that. That seems like a silly way to market to me. It seems to me you would want to push the sales event as well as the other vehicles at sort of your home lot. But I know that we do see this happen quite a bit. All right, another problem oftentimes are misleading claims. So, for example, the terms money-back guarantee or satisfaction guarantee, those terms can only be advertised if the seller will refund the full purchase price at the buyer's request and then discloses any limitations in the advertisement. So, for example, I know we have some clients who give like a 3-day, you know, you can drive the car, and if you don't like it, you're welcome to bring it back after, you know, within 3 days, and we'll refund all your money. Usually, though, there is a limitation. So you cannot take the car for 3 days and drive it for 30,000 miles in those 3 days. That would not be acceptable. So many times there's a mileage limitation on, I'm trying to think what other limitations I've seen. I think it's primarily mileage. And if you do, in fact, have a mileage limitation, then that limitation needs to be advertised in the same type and size font as this money-back guarantee or satisfaction guarantee is advertised. Okay, this is one which I can tell you one of our clients got into trouble with, and that is calling themselves the #1 dealer. Well, they might be the #1 dealer, but how are they going to substantiate that? And that is pretty tricky, because you have to be able to show, if you're the #1 dealer, that you sold more vehicles than any other dealer in your area. And that's another issue. I know this one client who had this problem. They just said, we are the #1 dealer. It didn't say we're the #1 dealer in Georgia. We are the #1 dealer in Atlanta. We are the #1 dealer in the world. I don't know where they were the #1 dealer. And unfortunately, they paid a pretty substantial fine because of that, because, of course, the Governor's Office of Consumer Protection couldn't determine where they were the #1 dealer either. So I would recommend that you avoid the use of that term. All right. On my next slide, this is, I don't know, it seems self-evident, but a rule which some dealers are able to violate is that advertised vehicles must be sold at their advertised price, even if the consumer has no knowledge of the sale. So I'll give you an example. My husband and I recently bought I call it a new used vehicle for one of our children, and the vehicle had been advertised on the web. We had the advertisement that said, you know, it was going to be sold for X price. We went into the dealership to buy it. And the salesperson, being very honest, said, oh, well, as a matter of fact, today we reduced the price on that vehicle by $1,000, and he actually showed me the new pricing sheet with the price of the vehicle reduced by $1,000. And that's exactly what he should have done, because that vehicle had to be sold at that price or lower. He could not have sold it to me at the higher price, even though that was the ad that I brought in. I had the ad from the day before. So there's an example of a salesperson and a dealership that did the right thing under the circumstance. Sometimes you'll see that advertisements have a requirement that you have to bring in the ad, or maybe there's a coupon printed in the paper or something like that in order to get that advertised price. And that's okay. I mean, frankly, I don't think it's very customer friendly, but okay, if that's what you want to do, that's acceptable and would not be found to be a misleading or deceptive advertisement. So here's some Georgia examples again, and again, these are examples I think that could be used nationwide. So if you have certain advertised vehicles, you have to have a sufficient supply of those vehicles. You can't advertise using the term select models. Like, for example, sometimes you'll see, you know, select models at $20,000 or something like that. That is not good enough. You have to say we've got 8 vehicles at $20,000. The terms limited supply or quantities limited are acceptable and would not be found to be deceptive. If the advertised vehicle is not in stock, however, it's being advertised anyway, and this would really only apply to a franchise dealer, because I can't imagine how an independent dealer could advertise this way. But under this circumstance, if the advertised vehicle is not in stock, advertisement must disclose that the vehicle is only available by special order. All right, so examples, I talked about this a little bit, things which just make the regulators insane. It's the use of an asterisk. So you see my gigantic asterisk up on the upper right-hand corner of my first bullet, and then you see down in the lower left-hand corner of this slide in tiny type and in a different font and not bold, the modifying information for that phrase, and that's not good. That's not good. It would be found to be deceptive. The next slide, or the next bullet on this slide, shows the problem with using color contrast. Sometimes, you know, you use different colors in your ad, and particularly on the websites, you'll see this. And I really do think that you're trying to make something look better than it would if it were all in black and white or all in, you know, two colors or something like that. But sometimes, you know, I think maybe the proof looks different than the final product, perhaps, because I really think that oftentimes the dealer's not trying to be deceptive, but the final product ends up being deceptive. So in this circumstance where there's that, I don't know if it's like a light blue or kind of a steel gray or something color, you know, that's just more difficult to read than the black print against this light gray screen. So I would encourage you to always look at the final, not just rely upon a proof before you put it out there to the public to make sure that the colors are not deceptive. The next bullet here talks about unexplained abbreviations. So here we go. WAC, OAC, TT, and L. Okay, we know what those mean, but I can tell you that the general public has no idea what those mean. And so you shouldn't use those because, again, you need to think about what would a consumer walking off the street who's not a member of the car industry know when they look at an advertisement, and these abbreviations just don't work. And frankly, I did that myself with you guys when I started talking about the FTC Act. And I bet many of you had no idea what I was talking about, and I apologize for that because I should have said right from the start the Federal Trade Commission. So there you go. I was deceptive, but I don't want you guys to be. All right, we talked about this already a little bit, and this is the whole thing with using photographs which are not the photographs of the specific vehicle. And again, this deals primarily with our independent dealers. And you cannot use the term for illustration purposes only. We had a client who got nailed for that. And the problem, of course, is if you're a big car lot and you've got your web advertisement up and you've got 50 vehicles advertised and it says for illustration purposes only under every single one of those vehicles, you now have 50 violations. And that is a pretty substantial fine. So please don't use that term. My next bullet here, so terms such as select models or a special selection can only be used if the advertisement specifies which vehicles are in fact the select models or a special selection. So you've got to be extremely careful. And you know, think about it for yourselves. If you walked to a dealership and you said, here, I'd like to look at this vehicle, and they said, oh, it's select models, and you as the consumer don't know which vehicles those are, well, then that would be found to be deceptive advertisement. All right, I've tried to talk to you a little bit about the Internet because I do think it presents special problems sometimes because of the way that the screens are presented to the consumers. It's extremely important that the disclosures appear on the same screen as the trigger terms, and we're going to talk about the trigger terms in just a minute. Any hyperlink to the disclosures must be obvious and in proximity to whatever it is that they're modifying. And so I've given an example here where the hyperlink is in this bright blue that stands out and it's underlined. So that would bring it to the consumer's attention. And you cannot hide disclosures in the middle of online advertisements. It's just like in your print ads. The disclosures need to be in the same type and font as the rest of the advertisement. All right, doc fees. This is a gigantic problem, I can tell you. And this is a gigantic problem in Georgia, and I presume it's a gigantic problem in other states. So in Georgia, our regulator says that the fee that you advertise is the fee that you're going to sell the vehicle for, except for government fees. That's the only thing that you can add to the advertised price of the vehicle. And this, you see the example that I've given down here. This is from an actual advertisement, which we found as we were preparing these slides. And it says the price is plus government fees and taxes. That's fine. Any finance charges, not permitted. Any dealer dot processing charge, not permitted. So that advertisement would not be permitted in Georgia, and I expect would not be permitted in other places. And I'll give you the perfect example. So I gave you the example already of my buying the car recently for my son, and how nice the dealer was because he sold it to me at the price that was advertised that particular day, not the day of the advertisement that I brought into him. Okay, that was very nice. What was not very nice was that when we got the buyer's order, it had plus a doc prep fee of $599. Well, that made my husband insane. But it was 8:30 on a Wednesday night, so we bought and I explained to the salesperson what I do for a living and why that was not permitted under the law and that it was deceptive. He was not persuaded by what I was telling him. So we went ahead and bought the vehicle, and then I sent a very nice letter. Owner, or actually I guess it was the president of the dealership, and I explained to him what the law was, and I got a check back for $599, which I appreciate. So I think in order to avoid those kinds of claims, you just got to be really careful. And I know this is the one that my clients say, but everybody does this. Everybody does a dealer doc prep fee, you know, some kind of a fee in addition to the advertised price. And my response is everybody going to help you pay your attorney's fees and pay your fine when you get penalized by the state? So if they are, that would be fabulous. You have better friends, I would say, than most of our clients do. But I think this is a very dangerous practice. And then let me caution you on this, one other thing on this slide, too, which as I now can't remember if I have a slide particularly on this. So we say all fees except government fees, tax, tag, title. Okay, but it has to be the actual tax, tag, and title fee, not some made-up fee just because you like $50 or $40 because it's a round number. I like a round number too. But if that's not the actual number, then no, you cannot charge that to your customer. And frankly, that back to my buying my car recently, this was my third problem with it. We were charged a $40 tax or a $40 tag fee, and then after I wrote my letter, you know, to the dealership, I got the tag back, and in fact, the fee was $18. Okay, so I could have, I guess, sent them another letter and asked for an additional refund, but I didn't do that. But you know, it's a problem. It's deceptive. It's not only deceptive; it's just plain false, and you know, and it's not the right thing to do. So so please avoid that. All right. If you require some kind of a dealer fee at delivery, then you cannot advertise no money down. So that's a problem, and I know you see that every day as well. So if only the government fees are due at signing, so your tax tag title, then a no money down claim is perfectly fine, and you can advertise that. All right, so for our franchise dealers out there, MSRP, of course, must be stated for all new vehicles. If your ad says, for example, $4,500 off MSRP, then the MSRP must be listed for comparison purposes. Because there is no MSRP for used vehicles, you cannot compare used vehicle prices with the original MSRP. However, you will see that every day. I mean, I hate to say it, but you do. I mean, this is a problem even for our independent dealers out there, because they, I don't know why, but they think in their mind somehow that, and this is the example we have here in our advertisement too. I'd like to know what kind of car that is, where the MSRP is $126,000. But in any event, this is an example of deceptive advertisement. All right, wholesale. Once again, this is an example from a matter that we handled for one of our clients. You cannot use the word wholesale if you sell retail. Again, that's, and you know, my client argued, well, we sell them for wholesale prices. I said, well, did you sell it for the price that you bought the vehicle for at the auction? Of course not. No, they did not do that. And so it's deceptive, and you can't use that. You can't use the term wholesale to describe a low price for a vehicle. So please avoid the use of that word altogether. All right, other examples of terms that we see quite a bit which are deceptive. So for example, fleet prices. Well, a fleet price is when there's a discount because one purchaser is buying a large volume of vehicles at the same time. Well, if you're selling vehicles one by one, then no, you're not selling them at fleet prices, so you can't use that term. Factory prices, this also does not get it. And I hear all the time, you know, we've got a special allocation of vehicles, we're having a factory sale. No, you will get an enforcement action, at least in Georgia, from our Governor's Office of Consumer Protection. We see this a good bit, particularly towards the end of the month. Prices slashed. You cannot advertise that way unless the prices, in fact, have been significantly reduced from the original price of the vehicle. And if that's the case, you need to be able to prove that. Because I can tell you that the regulator is going to be asking you for proof of what the price of the vehicle was before you slash the price. I can't say the word, slash the price. All right, on your credit statements, and again, oh my gosh, we hear this all the time, guarantee credit approval. I hear examples, you know, we'll approve credit scores as low as 550, as low as 500. There's one dealer I hear that advertises, oh, we just approved a customer this weekend with a credit score of 500. Well, I hope that's true, because if the regulator asks that you prove that, I hope you can prove it. These words, guarantee credit approval, or regardless of credit, or pre-approved credit, should not be advertised unless they refer to a specific individual. Or if, I suppose if in fact it doesn't matter what the credit score is, what their credit is, and you're going to approve every single person who walks in the door at exactly the same interest rate, then maybe you could advertise that, but I think it's very dangerous. All right, so here's an example of a deceptive advertisement. All credit applications accepted. Well, okay, we know that means that the dealer will actually take out of the consumer's hand the credit application. So, okay, the dealer will argue, well, I did. I accepted every credit application. But the problem is that consumers believe that the word accepted means approval, and therefore the regulator is going to find that this advertisement is deceptive. If a condition of a sale depends on a credit score and the dealership does not advertise the acceptable credit score, then that doesn't work. And the other thing is, well, it's just really dangerous to advertise a credit score, because what the regulator will also say is how do you know that you're going to have enough consumers walk in the door who will be of that credit score or higher that can get approved for credit? And so they're going to say that it was basically a bait and switch, that you got consumers to come in who maybe wouldn't qualify, and then you sold them a vehicle and financed it for them at a different rate, and now you got a problem. So you've got to be extremely careful when you condition sales on credit scores. All right, we hear this a lot. With approved credit, that's acceptable unless the advertisement implies that a consumer has been pre-approved. So you've got to look at the context of the entire advertisement when you use the terminology with approved credit, and again, be really, really careful doing that. All right, do not advertise the term beacon score at all. The FTC believes that this is a term which consumers do not understand. They might, they understand what their credit score is, but they don't understand sort of the term of art beacon score. And it's very, I would really encourage all of you to take a look at the FTC's website. They have a wealth of information on there for consumers. It is really very educational, I think, for consumers and for the dealers. The FTC does surveys, I guess, and they actually do meetings with consumers to test different terms and different advertisements to see, how consumers read these, and that information, a good bit of it anyway, is up on their website, and I think you'd find it very educational. And this is how they came up with this about beacon score not being a consumer-friendly term. All right, so you guys probably know this, but under the Truth in Lending Act, which we call TILA for short, there are certain terms that if you advertise those terms, then other terms are triggered. So that's why they're called trigger terms. So if any of these terms are advertised, it's the amount or the percentage of a down payment, the number of payments or the period of repayment, the amount of any payment or the amount of any finance charge, then you also have to include the rest of these in your disclosure. And it has to not be down there in the mice type at the bottom of the ad. It needs to be in close proximity to whatever word triggered it. So you would also have to disclose the amount or the percentage of a down payment, the terms of repayment, and the annual percentage rate. And I've got on this slide that the term APR, which stands for annual percentage rate, is not considered to be consumer friendly. So I would encourage you to actually write it out, annual percentage rate. Similarly, for lease transactions, there are trigger terms also. So if you advertise for a leased vehicle and you advertise the amount of a payment or any statement that deals with the capitalized cost reduction or payment prior to consummation or delivery, then you also have to disclose the following information. You have to specifically state that the transaction is a lease. You have to state the total amount due prior to or at consummation or by delivery. You have to state the number, the amounts, and due dates of scheduled repayments. You have to state whether or not a security deposit is required. And there needs to be a statement that an extra charge may be imposed at the end of the lease equal to the difference between the residual value and the realized value of the vehicle. All right, let's talk about promotions. These seem to be really popular for a while, but I actually haven't seen them, at least in Georgia, lately. And the examples that I'm giving you, these regulations, I would say, are very state-specific, and so please check with your own state law and with your local council for the rules in your own state. But so, for example, the promotion has to have a verifiable retail value. which is the actual retail value or 3 times what the dealer paid for whatever for the prize, and the odds of winning. And the odds need to be in the same type and typeface, same boldness as the prize itself. So you can't say, win this fabulous, 2002 Cadillac Coupe de Ville or whatever, and then in tiny print put odds 1 in a million. No, so that would not work. In Georgia, our regulators have said that promotions that do not conform with our promotion rules are illegal lotteries, and therefore may be considered commercial gambling enterprises, which are illegal in Georgia and, in fact, are a felony. So you don't want to get yourself in trouble with the criminal authorities just because you want to have some kind of a promotion or a contest. Unless it's disclosed in the advertisement, then a consumer participating in a promotion cannot be required to hear a sales presentation in order to participate in the promotion. I've got you an example from Washington. So in Washington, there's a specific rule that says there are no substitutions of prizes which can be made. And if the prize is unavailable, then the consumer must receive a certificate from the sponsor who has 30 days to honor. And if the prize cannot be attained, then the sponsor must pay the prize's verified retail value to the consumer. So that's a pretty specific requirement. In Georgia, back to Georgia here, back to our other coast, the geographic area which is covered by the promotion, if it's limited, must be clearly stated in the advertisement. And I expect it is limited, so if you're a dealer here in Atlanta, you might limit the promotion to Atlanta customers or, customers in Georgia or something like that. And no consumer can be forced to pay the cost other than the travel expenses to take part in a promotion. So you can't have it, for example, if you're doing a promotion, you come in and we'll hand you a key, and if your key opens the car door, then you win that vehicle. Well, okay, you would have consumers from all over the country, perhaps, coming for that, and, okay, they have to pay their own travel expenses, but when they get to their dealership, you can't say, oh, but you have to buy this raffle ticket, and the raffle ticket's $100, and then once you buy the raffle ticket, then we'll give you your key. That would not be permitted. All right. If you are doing a mailing to your customers, or to not customers, to your prospects, I guess, then the mailing, and this is a specific Georgia requirement, it has to have lots of information. It has to have the name and address of the promotional sponsor, the verified retail value of the prize or whatever the giveaway is. It has to have the odds of winning, the conditions to receiving the prize, any material limitations to the offer, and then there also has to be a clear and conspicuous disclosure that there's no purchase necessary and a purchase will not increase your odds of winning. That's a lot of information to put on a promotion flyer. Here's an example from Washington. If you use a simulated coupon, then that simulated coupon must state on its face that this is not a non-negotiable instrument, there's no cash value, and then it has to have the words, this is not a check, diagonally printed across the coupon in a predominant typeface. This goes back to when it was pretty popular, I think, to use what was called a live check, and you would get something in the mail that looks like a check, but of course it's not really a check. You have to take it somewhere and do something in order to perhaps win something. And so Washington specifically has these examples, and as do other states. So again, I'd encourage you to look at the law in the state where you do business. All right, here's an example of a scratch-off mailer. So if the prizes have little or no value, that's probably going to be found to be deceptive. If you advertise a promotion only as a means to have consumers visit your dealership and actually nobody is ever going to win, then no, that's not going to work either. So you have to get really, you know, if you're giving away prizes, you have to have actual prizes to give away, and you need to make sure if you're printing 1 million tickets that you have, and for example on this one, that there's more than one person who's going to win the $500 cash. The other thing we highlighted in this advertisement, which we thought was particularly bad, is in the upper right-hand corner where it says, "Congratulations, you hit the jackpot." But really the person did not hit the jackpot. So they think they've won the biggest prize, but no, in fact, they have not won the biggest prize. And then down, if you look down lower in smaller type, it says, "Must redeem prize in person during sale hours." And our regulators would find that to be deceptive because, and you guys know the answer to this by now, because that limitation, that disclaimer, is not in the same type size and the same distinction font as the rest of the advertisement. So that's a problem. Another example from Washington is that it is deceptive to require customers to reveal whether they will use a voucher or a coupon before price negotiations. So, you know, you've got a customer sitting there who the advertised price of the vehicle is $25,000. They negotiate with you. You agree to sell that vehicle to them for $23,000, and then the customer says, "Oh, and I have this coupon that I cut out of the paper today that says I get $500 off, so now it's $22,500. Well, that's exactly right. You have to sell that vehicle to the customer for $22,500. You can't say, "Oh, I didn't know you had a coupon. No, we're not going to use that because we already took $500 off the price of the vehicle." That would be found to be deceptive. Okay, here we go. Another example from one of my cases. "We'll beat any deal." Okay, that's perfectly fine if, in fact, you are going to beat any deal. So first of all, you have to be able to prove that, which might be a little difficult. So perhaps a better advertisement would be to say, "We'll beat any advertised deal," and then the consumer brings in an advertisement for the exact same vehicle, and you're willing to beat that. That's fine. The regulator would find it to be deceptive and unfair if you require the consumer to put down a deposit on the vehicle with a competing dealer. That doesn't work. All you've got to do is bring in the ad. They don't have to put down a deposit with that competing dealer. Or if you require the competing dealer to actually sell the vehicle to the advertising dealer, no, that's ridiculous. Or if you require production of a written offer from the competing dealer. So not just the advertisement, but an actual written offer from the competing dealer. So that's a problem. All right, upside down ads. You may have seen this advertised or the publicity press releases about the recent actions which the FTC took against 5 dealerships for upside down ads. And if you open your newspaper in your hometown, I bet you'll find some in today's newspaper, even though these dealers paid some substantial penalties. So these are advertisements, as you know, which promise the consumers that the dealership will pay off the consumer's trade-in no matter what is owed on the vehicle. So you can just hear that on the radio as you drive to work. We'll pay off your trade-in no matter what is owed on your vehicle. Well, what happens in reality? The negative equity is rolled into the consumer's new contract. So in fact, yes, they will pay it off, but the consumer is the one who actually pays the cost for that. But the consumers don't understand that that's what's actually happening. But we all understand that's exactly what's happening, and the FTC understood what was happening, and that was a problem. So these 5 dealerships were cited with the violations. There were 0, put that in capitals for y'all. There were absolutely no consumer complaints. This was something that the FTC found on their own and then did an investigation and went after these dealerships. You can look on the FTC's website if you're interested in reading the actual settlements and the commentary about them that the FTC put up. So, and as you know, I think probably, consumers believe that they'll get the guaranteed fair market value subtracted from the price of the purchased vehicle. But of course, that's not what happens. And that was something that the FTC found to be deceptive and unfair to consumers. I think I'll move along. So here's the, as a result of this settlement also, the FTC, in fact, has a new publication up on their website, which I would encourage you all to take a look at. I've got this is the link which will take you directly to their new brochure. And like I say, I think it's just really important for you to take a look at the FTC website periodically and see what new information they have up there for car dealers and for the car buying public. I would also encourage you to look at your state regulator's website, again, pretty frequently. I know here in Georgia, the Governor's Office of Consumer Protection has a really great paper about advertising, and then they also have sort of helpful buying and financing hints for consumers. So I would encourage you guys all to take a look at those things in your own states and frankly in other states as well, because you'll learn something from all of them so that you treat your consumers fairly. All right, the word free. You should not use the word free if the price of the vehicle is going to be the final price is arrived at by bargaining, because of course then it is not free. So the example I always give for people about this is when I was taking one of my kids around for college, and every college visit I think we went to, somebody said, oh, well, you know, we have free ice cream every Friday in this dorm, or we have, you know, free, I don't know, the kids get free concert tickets or whatever it is. And I'm sure I made these people crazy, but I would always say, well, it's actually not free. It's just included in the cost of the tuition. And they'd kind of look at me sheepishly and say, well, yeah, you're actually right about that. Well, of course, because we know there's no free lunch. And just like in your advertisement, you should not advertise things that are free. Okay, this, again, I would say not so much right now, because actually our gas prices in Georgia came down a little bit, although they seem to be creeping up. But when our gas prices were really high, we saw a lot of advertisement of gas cards or gas vouchers. And again, that's fine. You can give away a gas card to every single consumer who walks in your store on this Saturday and takes a test drive, for example. That's perfectly fine. But the gas card should be for a reputable station, which is sort of in the neighborhood. So if you're in Georgia, you cannot give away a gas card for a California gas station. And you have to make sure that the station does not require the consumer to do anything else. So, for example, if the consumer takes the gas card to the station, they're going to get their, you know, their $10 of free gas, and the station says, oh, well, we only accept that card if you buy a car wash today. No, that's not permitted. And I know that happens because, again, we've had a client who got in trouble for that kind of a thing. And, you know, our client said, well, we can't control what the vendor does. And I said, well, yes, you do. You can. You have to inquire. When you make that arrangement with the vendor, you have to make sure that you understand who you're dealing with. You have to make sure they're reputable. You want to be reputable, you want to make sure they are also. So add-ons and aftermarket items. frankly, I hope this is something that happened maybe 20 years ago but doesn't happen anymore, and that's with extended warranties, because I hope you know that you cannot require an extended warranty in order to be approved for a vehicle loan. So, just be really careful about that. Of course, there is no right to cancel a transaction on a vehicle unless you've advertised it. So you have to be, really careful. If you do require, so for example, if you finance the vehicle yourself and you require an extended warranty, you require some kind of insurance, that the customer has to purchase, then you've probably now also got a truth in lending violation, because I expect you have not appropriately disclosed those required items as part of the finance charge, and now you've got a problem there as well. All right, so lifetime warranties. What in the heck does that mean? A lifetime warranty means lifetime. Got that in big bold print here for you guys. So does it mean in the lifetime of the consumer? Is it in the lifetime of the vehicle? What if the consumer gets a lifetime warranty on a vehicle and then sells the vehicle the next day? What does that mean? You've got to be really careful if you advertise lifetime warranties. And what happens if your dealership goes out of business? Well, the reality is, if the dealership's out of business, then how are they going to honor any outstanding warranties? But if your state regulator comes knocking on your door and asks you that question, how do you intend to honor all these lifetime warranties which you have either sold or given to your customers? What happens if you go out of business? You better have a good answer for that, and you better have a way to honor those warranties, or you're going to have a violation. Okay, I know you guys have probably thought, why in the heck have I spent the last hour listening to this woman from Georgia talk about all of this? And here is why. Because the penalties are very substantial. So if the FTC decides that it's going to visit your dealership, you're their next target, then the penalty is $11,000 per violation, not per complaint, but per violation. So, for example, if you mailed out 20,000 flyers and every one of those flyers has a violation, you now have 20,000 violations. And so multiply 20,000 times 11,000, and you will see the maximum penalty that you could be assessed. There does not have to be any actual harm. As in the upside-down claims that we already talked about, you don't have to have any consumers complain about your dealership or about an advertisement. Regulators, including the FTC, can just decide on their own that they're going to come to an investigation. They're going to ask you for all of your advertisement. They're going to scrutinize them with a fine-tooth comb, and they're going to find a problem. And then you're going to have a penalty. In Georgia, for example, our Fair Business Practices Act, which is what FBPA stands for, it's violated if the very first contact with the consumer is made by deceptive practice. So it doesn't require repeated contacts. It can only require one contact, and you could have a violation. And then what other penalties? And this is the part that I think is scary. Okay, the money is scary enough. An injunction, okay, you sign an order, or if they go to court and they get an injunction against you that says you can't do X, Y, and Z anymore. All right, that's bad. This is bad. Worse, there could be a criminal referral to the Department of Justice. That would be pretty terrible. You could also, in addition to having an FTC investigation, you at the same time could also have a state enforcement action, either which could result in civil penalties and fines. And just because the FTC has already come after you, that's not going to be a good defense if the state comes after you as well, because it's a separate law with separate violations. And then, I mean, sometimes I think for our clients this is the worst part, which isn't saying anything bad about our fees, but unfortunately, trying to defend these actions can be really expensive. So, for example, we have a client who is under the being investigated right now by the Georgia Office of Consumer Protection, and they were required to produce, I think it was 100, it may have been more than 100, I know it was boxes of customer files. And, you know, just for us to go through those files, reproduce the documents, make sure we didn't produce something that was not being requested, that cost a lot of money for the client. And I would say we're pretty efficient, but I can tell you the attorney's fees sometimes can really be a lot. So here's what I recommend to you. It's much less expensive to have your lawyer review your ads and your marketing materials, including your websites, before you get them out there for the public. That is, it's so much less expensive to have somebody look at them up front than it is to have to pay somebody when there's an enforcement action against you. My number 2 recommendation is to make sure that you have written policies and procedures which tell your employees they cannot advertise unless, or market, I use the words advertisements and marketing materials. Because people don't think that what they're doing is an advertisement. So, for example, suppose you have an employee who hands out pens with some, I don't know, cute saying on it, you know, come to, I'll give you the lowest price in town. Come see me, Joe Jones. Well, that's an advertisement. The employee might not think it's an advertisement, but it is, and it's deceptive. So now you've got a problem. So I strongly recommend that you have written policies and procedures that require all of your advertisements and marketing materials, including business cards, to be approved by a particular person at the dealership. My 3rd recommendation, retain copies of all of your ads and marketing materials. Now, I know sometimes people think, oh, it's much better if I don't keep copies of everything, because then maybe no one will find out that we did something which might be construed to be deceptive. No, that is not a very good, that's a really bad idea. Because what happens is, of course, the regulator comes to you and they have the advertisement that they think is deceptive. And because they have one advertisement that they think is deceptive, sometimes they then believe that all of your advertisement is deceptive. And it's really helpful if you can show we advertised, placed 1,000 ads in the last 12 months. And only that one advertisement had a problem. It was a mistake. We told our marketing person not to do that. Look, here are these 999 other ads which were perfect. And that will go a long way to convincing the regulator that you have policies and procedures in place to make sure that you comply with the law and that you're doing the best you can under the circumstances. And then my 4th bullet here, my final recommendation, which you guys have probably already figured out from this, is that, yes, in this case you do have to sweat the small stuff because it's that small stuff that will get you in trouble every time. It's just really, it's really a problem. All right, here's some good resources for you guys. And I say look at what they're saying to the consumers as well as to the industry, because you will learn from everything. So these are the actual links to the FTC's website with their resources for you guys. If you have any questions, you're welcome to call me or email me. One thing, I don't know if I skipped over a slide or maybe somehow I omitted it, but I did want to mention one thing to you while I'm thinking about it with regard to websites. I mean, there are lots of website vendors out there that all of you guys advertise on. They're national vendors, and I'm not going to name them, but I can tell you that some of their disclaimers are not adequate under state law. So please, and that is not a defense. So if you advertise with a national provider and their disclaimer violates the law, so for example it says accept tax tag title and document preparation fees, that's not permitted in Georgia and other states. And the fact that you cannot change that is not a defense to the regulator. And the regulator will say to you, well, then you do not need to advertise on that national website. So please be really careful about that. You've got to look at everything in the advertisement. And I think that's my very last slide and my very last comment. We've got a little bit of time for some questions, so I will turn it back over to you.
Thank you, Terry. We will now begin our Q&A segment. I'll go over the written questions. The first question we have is, what are the most common mistakes you see?
Well, I think I've gone over a lot of those in my presentation. I think lately the most common problem that we've seen is in the whole not down payment, is in the document preparation, the doc fee. I think that's really common, and I think it's a huge problem out there. And that's how I got my $599 back. So I would really caution you to be really careful if you, in fact, charge a doc prep fee.
Thank you, Terry. Second question, does the Consumer Financial Protection Bureau regulate car dealers?
Well, it does. It does. And I'm glad whoever gave us that question brought that up. So I know there's been a lot of press out there lately about the Consumer Financial Protection Bureau, which we call the CFPB. And so you probably know that the industry lobbied really, really hard in order to avoid regulation because they're already regulated by the FTC. But it was one of those, we won some, we lost some. So under Dodd-Frank, the Dodd-Frank Act, which is what the CFPB, it allows the CFPB to regulate buy here, pay here dealers. However, it also allows the CFPB to regulate the financing of vehicles. So far, not been any regulations proposed, but we do expect them. You know, frankly, I kind of, every day I think today might be the day. So I would encourage you to watch the paper, watch your trade publications. I think we'll plan to have another seminar when the CFPB does propose some regulations which impact the auto industry.
Thank you, Terry. Do you expect FTC to be more active in enforcement against car dealers?
I do. I really do. I think, so what happened when Dodd-Frank came out is that the FTC lost some of its jurisdiction, not as to car dealers, but otherwise. And I think that the whole issue of whether car dealers should be regulated under Dodd-Frank, I think that whole issue, I don't know, just sort of like brought to the forefront consumers' complaints about car dealers. So because of that, I think the FTC has really a renewed emphasis on car dealers, which, you know, frankly is evident in that the recent actions which we talked about in the slides. So, you know, there's no time like the present, I think, to be as diligent as possible. You know, this presentation was all about advertisements, but it's not just in your advertisements, it's in your actual business practices as well. So it would be, you know, it's an opportune time for you to get with your local counsel and talk about what your business practices are and make sure that your practices are not deceptive in any way or unfair to consumers.
Thank you. The last question we have, do you expect state regulators to be more active in enforcement against car dealers?
I do. I don't know if it's a competitive thing or what it is, but I definitely do. We see that here in Georgia. I just think there's really a heightened awareness of, what are viewed with issues with some of the sales practices and advertisements that car dealers do. So I do think, yeah. And like I say, I don't know if it's competition. The states are saying, oh, well, gosh, the FTC is more involved, so we'll be more involved. I don't know. But I definitely think that all around there's just a much more enforcement than there has been in the past.
Thank you, Jerry. This is the conclusion of the webinar session. If you have any further questions or if you need more information, please contact Terry Franzine at tfranzine@franzine-salzona.com or at 770-248-2882. Again, it's 770-248-2882. On behalf of ATS, thank you, Terry, for such an informative presentation.
You're very welcome. It's been my pleasure.
And our attendees for joining the webinar. For more information on upcoming events, please visit our website at www.autots.org. Thank you and have a wonderful afternoon.